Good afternoon, everyone. My name is Preet Bharara, and I am the U.S. Attorney for the Southern District of New York. This past July, we filed a criminal indictment against 4 SAC capital-related companies for engaging in insider trading that was substantial, pervasive, and on a scale without precedent in the history of hedge funds. 3 months later, we are here to announce a resolution that is matching in its magnitude. All of the charged SAC companies have agreed to plead guilty. All have agreed to wind down and close their outside investment businesses. And all have agreed collectively to pay total fines and penalties in the record amount of $1.8 billion. Today's agreements, if approved, would resolve the 2 cases brought by the government against SAC in July, both the criminal indictment against the SAC companies and a separate civil forfeiture and money laundering action as well. Both agreements were sent this morning to the 2 district court judges presiding over those cases for their review and their approval. The plea agreement announced today, moreover, is solely between this office and the SAC companies and involves no individuals. It does not include pleas of guilt by any individuals, nor does it provide any criminal protection or immunity for any individuals going forward. Let me also stress that individual defendants who have been charged and are awaiting trial are presumed to be innocent, and the plea agreement announced today does not affect that presumption in any way. Now, before I discuss the agreement in more detail, let me introduce our partners in this investigation and in this prosecution. I'm joined by, I am so often in cases of this magnitude and importance, by the FBI, led by George Venizelos here in New York. Today, the FBI is represented by April Brooks, the special agent in charge of the criminal division. I want to thank George and April for their dedication and for the dedication of their teams of FBI agents, notably supervisors Doug Leff, Dave Shavs, and Kathy Diskin, and also special agents Matthew Callahan, B.J. Kang, David Makel, James Hinkle, and Matthew Thorson for their really incredibly hard work and assistance. We wouldn't be here but for all of their dedication and hard work. I also want to thank the many staff attorneys at the Securities and Exchange Commission, at the Enforcement Division, with whom we've worked so closely on so many aspects of this investigation and coordinated nicely with them as we always do. I especially want to thank and acknowledge the dedicated career prosecutors to my right who have made today possible. They are Arlo Devlin Brown, Antonia Apps, and John Zach. The AUSA is handling the prosecution on the criminal side, and their chiefs, Mark Berger and Anjan Sani. Also, Christine Magdo and Micah Smith for their work on the forfeiture aspects of the case, as well as their chief of asset forfeiture, Sharon Cohen-Levin. So let me take just a couple of minutes to go through and talk about the particulars of today's agreement with the SAC capital companies. Let me first make clear that what we're announcing today is that the government and the defendants have reached an agreement with one another. It is now for the courts to independently consider those agreements, and the agreements between the parties have no effect unless and until the courts grant approval. The main features of the agreements are fairly straightforward and are summarized in the chart to my right. If you take a look, as you know, from the indictment that was filed on July 25th, there were 5 counts. Each of the entities has agreed to plead guilty to everything charged in the indictment. The total penalties are 1.8. The total penalties, I will try to speak as loud as I can. The total penalties are $1.8 billion. They are divided as follows according to the chart, and as described in the papers that were sent to the court today. $900 million fine in connection with the criminal case. I'll go back to the podium. A $900 million fine with respect to the criminal case, a $900 million resolution with respect to the civil case, which means that's a total of $1.8 billion. As you may appreciate, the Securities and Exchange Commission reached an agreement with respect to SAC Capital and those companies to the tune of $616 million based on conduct that is overlapping with some of the conduct that we allege in our civil money laundering complaint. And so if you subtract that out, according to the agreement we have, they get a credit for that. And so the total additional payment beyond what has already been agreed to with the SEC is $1.184 billion. Other key terms of the agreement are that the entities agree to wind down in an orderly fashion their investment advisory business in a way and in a timetable to be approved by the SEC. They have agreed to accept a maximum term of probation after pleading guilty of 5 years, and have agreed to retain, with our consent and approval, a compliance consultant so that that person can make sure that everything is going as it should go at the entities during the period of their wind down. There's another key point worth noting about the financial penalty. Its burden will not fall on third-party investors. The SAC companies have made clear that no outside investor money will be used to pay the $1.8 billion penalty. The settlement terms, moreover, provide for an orderly wind down and payment schedule of this record penalty to minimize any market disruption. I should also stress that neither SAC nor any person paying any portion of the $1.8 billion penalty will be permitted to claim any tax deduction or tax benefit in connection with this payment. So that's what's in the agreement. Often, as is the case here, in addition to describing what is in the agreement, it's just as important to note what is not in the agreement. Here, there is no immunity from criminal prosecution for any person, as I mentioned. In fact, as I said, this agreement does not have any binding effect on any individuals at all, either charged or uncharged. And so while the agreement today may end the government's prosecution of the SAC capital companies, with respect to individuals, either at this hedge fund or the countless other financial institutions that buy and sell securities, we will continue to pursue insider trading investigations and follow the facts wherever they lead. And the investigation, in this case, on the criminal side, remains ongoing. Now, as I said just about 4 years ago, at the time of our first major insider trading arrests, greed sometimes is not good. And there are at least 75 convicted insider trading defendants who today would likely agree. But individual guilt is not the whole of our mission. Sometimes, blameworthy institutions need to be held accountable too. No institution should rest easy in the belief that it is too big to jail. That is a moral hazard that a just society can ill afford. Law enforcement should not shy away from holding institutions responsible when it is justified and necessary for both deterrence and accountability. Whether the misbehaving corporation is a hedge fund, or a commercial bank, or a manufacturer of a popular product, because sometimes institutional punishment is essential to serve justice and to deter misconduct. Today, one of the world's largest and most powerful hedge funds agreed to plead guilty, to shut down its outside investment business and pay the largest fine in history for insider trading offenses. That is the just and appropriate price, in our view, for the pervasive and unprecedented institutional misconduct that occurred here. Now let me call to the podium April Brooks, our partner from the FBI.
Good afternoon. In 2006, with new information about rife and unbridled insider trading at hedge funds, the FBI went to work. After examining trading anomalies, poring over documents, conducting surveillances, and making the first approach to a key target, that individual began cooperating with the government. What started with a key cooperator led to thousands of hours of relentless investigative work by a team of FBI agents uncovering an extensive network trafficking in insider information throughout the hedge fund industry, a network that has been chronicled by many of you. The result, in part, brought today's plea and is the latest step in the largest insider trading investigation in history. None of this would have been possible without dedicated prosecutors willing to bring charges here in the Southern District, led by U.S. Attorney Preet Bharara and Deputy U.S. Attorney Richard Zabel. I would like to recognize Assistant United States Attorneys Arlen Devlin Brown, Antonio Epps, John Zak, and their chiefs, Mark Berger and Anjan Sani. I would also like to recognize the team from my office, FBI Special Agents Matthew Callahan, James Hinkle, Matthew Thorson, B.J. Kang, and David Makel. I also want to emphasize today's announcement has no effect on any individual awaiting trial. Those defendants are presumed innocent until proven otherwise. What SAC Capital's plea demonstrates is that cheating and breaking the law were not only permitted, but allowed to persist. SAC focused on hiring the best talent who was equipped with extensive networks to circumvent traditional lines of communication, talent who would be prepared to get confidential information to fuel their illicit trades. SAC didn't just break the law. Their illegal activity resulted in insider trading that was substantial, pervasive, and on a scale without known precedent, according to the July indictment. It was nothing short of institutional failure. In today's agreement, SAC Capital will plead guilty to all 5 counts in the indictment. The result is $1.8 billion in fines and forfeiture, the largest penalty in an insider trading investigation ever. Most importantly, SAC Capital will terminate operations as an investment advisor and will be required to have real, genuine compliance overseen by an independent expert. In layman's terms, SAC will no longer be able to invest anyone's money but their own. As today's plea illustrates, SAC institutionalized their practices by cultivating a culture of corporate corruption. To those on the street who venerate Michael Douglas's character of Gordon Gekko, understand this: principles are just as important as your profit. The problem of insider trading is real, and for companies that willfully turn a blind eye, be on notice. How your employees make their money is just as important as how much they make. Today is not the end. The FBI's investigation into insider trading on Wall Street, on Main Street, in hedge funds, in expert networking firms, and anywhere else continues. We will relentlessly pursue this anti-competitive criminal behavior until every portfolio manager, every trading desk, every hedge fund owner stops trading on insider information. Thank you.
Thank you, April. Happy to take your questions. Yeah. Today's announcement is with respect to the companies that were charged by this office on July 25th, and the resolution is limited to those companies. And as I said before, and I'll repeat again, there is no immunity or protection for any individuals from criminal prosecution or investigation. Yeah.
What does a 5-year probation term actually mean in practice?
Well, it means, as it always means in any kind of criminal case, if someone misbehaves, there's additional penalties that can be brought to bear. And I'll just refer you to the plea agreement itself, which lays that out. Yeah.
So the hedge funds had to come in and plead not guilty before Judge Swain in the criminal case. Do they have to go now in with the general counsel and plead guilty?
Well, the agreement is for them to plead guilty, and that's done by an appropriate corporate representative at a time that the judge, if the judge approves the agreement, would set at some point in the future. But yes.
So it's 2 parts. The judge has to accept it, and then the entity has to come and plead guilty.
I mean, that can all happen in one proceeding. I'll leave that to the court, and you should direct your inquiries to the court about how that judge would like to handle the resolution here. Yeah.
Why is there no cooperation agreement as part of this?
You know, sometimes plea agreements are cooperation agreements, and sometimes they're straight pleas, and this one is a straight plea. Yeah.
2 questions. One is, what would happen to the money that you're collecting? Where is it going to go? The fine and the forfeiture, different places maybe? And secondly, would the compliance requirements in the settlement apply after they return the outside money and have their money in the family office?
I don't remember the answer to the last question. I'll refer you to the document. Where does the money go? It goes to the United States Treasury, and then depending on what other proceedings happen and what claims are made, will be distributed thereafter. But it all goes to the same place.
There's no designated place that can pretty much be used how the government wants to.
Yeah, I mean, it is used in the same way that all money that's forfeited and all criminal penalties, it's in that same fund. Yeah, yeah.
Whose money is it? I guess I'm having a difficult time looking at a corporation as a defendant. I know this does happen in legal proceedings, but if you can just explain to us how. It looks as though the companies are almost destroyed, but then they're on probation for 5 years. And whose money is it?
Yeah, I think you're asking multiple questions, but
Yes.
what I made clear in the remarks and what the companies have made clear is that Obviously, there's money that exists in accounts and corporations, and sometimes they're bound up in securities, and sometimes they're held in part in cash. And what the companies have made clear that wherever it is coming from, it is not coming from the holdings held by outside investors in those funds. And you can draw your conclusion as to what that means then. Yeah.
So how would the compliance consultant be selected? Who's that going to be if that's been decided? And then if Stephen Cohen were to leave the firm, start his own new firm, would he still be subject to those compliance?
No, the first thing is, these are proposed agreements between us and the SAC entities. They still have to be approved by the court, and so nothing is triggered until there's an approval by the court. At that point, if you take a look at the plea agreement, you'll see it set forth there. I forget what page it's at. I think within 10 days of sentencing, there's supposed to be a discussion about who the consultant should be, and that person has not been selected yet. I forgot what the second part of your question. Again, there is no resolution here with respect to any individual, like I made clear. So if an individual decides that he or she, who had been associated with SAC Capital, decides he or she wants to open up a new hedge fund, that person would have to go through, obviously, the approval process with the SEC. And as you may be aware, the SEC, Securities and Exchange Commission, has a pending administrative action for failure to supervise against the principal of SAC Capital. And so that person would have to get the approval of the SEC to do something different outside of the ambit of the SEC Capital companies. Yeah.
After 5 years, this is being the part of probation that after 5 years that Steve Cohen can manage outside members.
These entities will cease to exist at that point, and our agreement says nothing about any individual being able to manage outside money. Our agreement is with respect to these companies. And as I said, the SEC, who's the primary regulator on issues of this consequence, has a pending action against the principal of SAC Capital, and that case has not yet been resolved. Yeah.
How would you describe the victims in this case?
I mean, as I've said many times, and as other people have talked about this case, there are all sorts of victims in this case. Some of the victims include everyone who believes that the markets should be fair and that the same rules apply to everyone. Other victims include potentially companies who had individuals there who were stealing their information about what kind of money they were making and selling it to people in advance of when it was becoming public. I'll tell you who another set of victims are in the broad sense, and some of the people who are most vindicated by the result today if it's approved by the 2 district court judges. And that's people who are honest in the business and who are honest in hedge funds, and there are many, many more of them than there are dishonest people. And those people are the ones who are really vindicated, because when you take the people who are, and the institutions that are not playing by the rules, off the playing field, then those people who are doing it the right way and the honest way with integrity and care about compliance and care about making sure they're doing things by the rules, then their activity is vindicated in that regard. Yeah.
So based on what formula do you conclude that this was a fair penalty?
You take everything into account. Yeah, there's some art and some science to it. Given the amount of insider trading activity that we have alleged with respect to those entities over the course of a long period of time, if you go back and read the indictment, it talks about a long period of time. It talks about a lot of different securities. It talks about a lot of different people. It talks about a lot of sectors. And if you take a look at the amount of money that the companies have made, this seemed to us to be a fair but steep and equitable resolution, so that, it's tough in the sense that it's several orders of magnitude larger than the identified avoided losses and gains made by the companies over the time that we allege in the indictment. It also represents something like 20 to 25% of the remaining funds in the hedge fund as a whole. If you take a look at the sentencing guidelines that are applicable to this case, which are not binding, but they're discretionary, but they mean something, I believe, as you see set forth in the plea agreement, that the sentencing guidelines range is something on the order of, on the criminal side, $800-something million. So we have sought a penalty on the criminal side in excess of what the maximum you might calculate under the sentencing guidelines is. And to take all those things together in order to send a message of deterrence, in order to make sure there's a proper exacting of a penalty, and given the magnitude of the activity and insider trading conduct, this seemed to us to be, as again we said in our letter, steep but fair. Yeah.
So taking into account that this is very significant and that you're still investigating, what would you say to people who say that, not charging the person who was essentially the top of this and who was responsible for a pervasive criminal organization
What has happened today is a very substantial and important thing. It is a rare thing for any entity to be held to account as an entity, and that has been historically true for a number of years now. It's then even more rare for that entity to plead guilty to everything that it has been charged with. And not only rare, but unprecedented to have a criminal fine and penalty of the magnitude that we have described it. As I've said, a number of people have been charged and convicted, and the investigation remains ongoing. And we are not shy and retiring people. These folks aren't, and these folks aren't either. And we're not unaggressive. And we bring cases when we have proof beyond a reasonable doubt that we can convince a jury unanimously of someone's criminal guilt. And when we get to that point with respect to anyone, whether it's at the top or at the bottom or in the middle, we bring the case at that time. Last question. Somebody who hasn't been. Yeah.
Well, just for the sake of clarity, are we talking about, when you talk about winding down investment advisory business and then also 5 years probation, are you talking about putting an end to the SAC Capital companies? Or are you talking about making it dormant for 5 years with the option of starting back up?
Those companies are winding down and are ending on a schedule that will be figured out by the SEC and subject to the SEC's approval.
So what is the probation?
You know, you have an insurance policy with respect to how long the wind down takes. My expectation is you don't need the whole 5 years necessarily, but it's there. Final question.
4 years ago, you said consider trading this brand on Wall Street. To what extent is that still true today?
Well, anecdotally, the suggestion is that it's less than it used to be. You know, we have seen from cases that we've had, including in wiretaps, of people who had not yet been charged when we were conducting some of the arrests that we were conducting. You can tell from their conversations that they, you know, were a little bit more hesitant to engage in that activity. If you look at the nature of the legal business and the nature of the compliance business at a lot of places, they will tell you anecdotally that a lot of hedge funds have come in and a lot of other institutional traders have come in to try to figure out ways to figure out red flags better, have tried to figure out ways to deal with expert networking firms better, have tried to figure out ways to make sure that their hiring practices are better. So overall, it seems to me, from anecdotal evidence and also from common sense, that when you see, you know, 75 people and counting who are criminally convicted and who had every privilege and, you know, every bit of education and every opportunity and money to spare, being convicted and being separated from their liberty in most instances, that has a deterrent effect on other folks. It's impossible to quantify completely, but our sense is when you talk to people in the industry that it's less than it used to be. Okay, thanks very much, guys.